Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
A party list group's registration with the Commission on Elections gets cancelled on the basis of acts that happened from more than 10 years ago. As a result, even its current nominee to the House of Representatives got booted out, and another party list group took its place. Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 27th of September 2024, and today we talk about what happened to An Waray Party-List. This is an en banc ponencia written by Associate Justice Alfredo Benjamin S. Caguioa, decided on August 6, 2024. And joining us to discuss this case is Supreme Court spokesperson, Attorney Camille Ting. Hi, Attorney Camille. Welcome back to the Supreme Court Podcast.
Hi, Attorney Mike. Thanks for having me again.
All right. So, Attorney Camille, this is a fairly recent decision by the Supreme Court. But tell us about An Waray Party-List and why was its registration questioned before COMELEC?
An Waray is a duly registered multi-sectoral party list organization. A petition was filed to cancel An Waray's registration before the COMELEC for violating Republic Act No. 7941 or the Party List System Act. Pornias and Asidre, who filed the petition, claimed that An Waray allowed its second representative, Victoria Isabel Noel, to assume office in Congress even though An Waray knew it was only entitled to one seat. So just a brief background, if it's okay, Attorney Mike.
Sure, go ahead.
Okay, so during the 2013 national and local elections, An Waray won a seat in the House of Representatives. The COMELEC, acting as the National Board of Canvassers, issued a resolution canceling the registration of some party list groups, resulting in the adjustment of seat allocations.
So how was An Waray affected by this new ruling?
So because of this adjustment, An Waray's number of seats was increased to 2. It must be noted that the resolution provides that this was without prejudice to the proclamation of other parties, which may later on be entitled to one guaranteed or additional seat.
So what happened to this resolution by COMELEC? Was it ever enforced?
Well, yes. So the National Board of Canvassers, pursuant to the resolution, proclaimed An Waray as one of the winning party lists, which entitled its first nominee, Montejo, to sit in Congress. He took his oath of office and assumed office thereafter. Based on this same resolution, An Waray's second nominee, Victoria, likewise took her oath and assumed office. However, later on, the COMELEC issued a second resolution where it declared the final distribution of seats for the party list group in accordance with the Supreme Court's computation in the case of Banat versus COMELEC. In the second resolution, An Waray was only entitled to one seat.
So there's an issue now, what will happen to the second seat occupied by Victoria? Do we know from the facts if she ever continued serving or was she booted out because of this new ruling from COMELEC?
So Victoria continued serving her term during the 16th Congress, and this is actually what prompted the petitioners to file the petition for the cancellation of An Waray's registration.
Which happened in 2019, long after her term, right?
Yes, that's correct.
Did the COMELEC still accept the petition, even despite the fact that her term was already finished?
Yes, it did. Actually, the COMELEC ended up canceling An Waray's registration. It said An Waray violated the law when it allowed Victoria to assume office. They said that Section 13 of the Party List System Act requires prior proclamation by the COMELEC. In Victoria's case, there was no proclamation before she took her oath and assumed office.
So they were questioning what happened during the 2013 elections, even after she finished her term, and the case was filed 2019, and that petition still won.
Yes.
Right? So what happened to An Waray after that ruling? Did it contest the ruling of the COMELEC?
An Waray filed a petition before the Supreme Court wherein they raised several grounds. The first one is they claimed that it is not the COMELEC, but the House of Representatives Electoral Tribunal, or the HRET, which had jurisdiction over the case. They said that since it involved the validity of Victoria's proclamation as a member of the House of Representatives, it therefore involves election returns, which they say is under the HRET's jurisdiction. The second issue is that An Waray's right to speedy disposition of cases was violated when the COMELEC failed to resolve the petition within 60 days as mandated under the Constitution. In this case, it took COMELEC 4 years to come up with a decision. And third, the supposed violation, they say, had already prescribed because under the Omnibus Election Code, election offenses prescribe after 5 years from the date of commission. In this case, the alleged offense was committed in 2013, or more than 10 years ago.
This question of jurisdiction between the COMELEC and the House of Representatives Electoral Tribunal is a frequently asked question. It happens in almost every elections. So what's a good guide between when a case should be filed before the COMELEC and when should it be filed before the HRET in the context of party list groups?
Okay, so in this case, it is the COMELEC which has exclusive jurisdiction to rule on the cancellation of party list registrations. On the other hand, the jurisdiction of the HRET is limited only to contests relating to the election, returns, and qualifications of incumbent members of the House of Representatives.
Can this not fall under the qualification of the nominee of the party list group? For example, the nominee of An Waray, can I not say he's not qualified or she's not qualified in this case because the registration has been cancelled, or in fact, they committed an act which make them disqualified from having a nominee. How did the ponencia settle this issue?
Well, in this case, it wasn't the member of the House of Representatives that has the issue. It was actually An Waray as a party list.
Mm-hmm.
So the court laid down a two-tiered test to determine whether the HRET must assume jurisdiction over a case. The first is whether the nature of the case is one of a contest relating to the election, returns, and qualifications of the person or the respondent whose qualification you are questioning. And second is whether the person whose qualification is questioned is a member of the House of Representatives. So applying this test in this case, the court said that the nature of the petition to cancel An Waray's party list registration is not one of these cases, which falls under the HRET's jurisdiction.
On that point, Justice Amy Lazaro Javier, who registered the sole dissent in this case, actually said we shouldn't give COMELEC the whole blanket authority when it comes to registration and cancellation of party list organizations. She was saying that if you look at the situation, the original cause might be about the cancellation of the party list registration, but the actual result is the removal of a sitting member of the House of Representatives. So wouldn't it make sense if it's actually the HRET who will have jurisdiction over this? Because you're removing a member of the House of Representatives.
Yes, regarding that, Justice Kagiwa explained that it is the law which gave COMELEC jurisdiction over the cancellation of the party list's registration. So regardless of the outcome, it is the law that must be followed.
So in this case, because the root cause of the question was really about the registration of the party list, it doesn't matter if the result would be to put out a member of the House of Representatives. You still go to the root cause of the whole issue.
That is correct.
Right. And what about this other issue that was raised by An Waray? They were saying this case happened more than 10 years ago, in 2013, in fact. And so our right to speedy disposition of cases was violated because it took a while before this case was resolved. What did the ponencia say about that?
The court said there was no violation because despite the delay on the part of the COMELEC, An Waray failed to show that it suffered injury from the pendency of the case. This is true, since during the same period it actually was able to participate in the elections, securing a seat in the present Congress. The court also said that An Waray waived its right to speedy disposition of cases when it failed to question this or bring up the issue before the COMELEC.
Okay. One right that's often confused with speedy disposition of cases is the right to speedy trial. How did the court actually distinguish the two in this particular case? Because those two are often brought up in cases like this, but one is inapplicable.
That's okay. So the court distinguished between the right to speedy trial and the right to speedy disposition of cases. The right to speedy trial applies to criminal proceedings as well as administrative proceedings that may result in criminal liability, while the right to speedy disposition of cases applies to any court or tribunal, whether judicial or quasi-judicial, such as before administrative agencies.
So between the two rights, Attorney Camille, right to speedy disposition of cases and right to speedy trial, is there like a hierarchy? Which one is more favored, or which one has a higher threshold that you should reach before you can invoke it?
Oh, so between the two, it is the right to speedy disposition of cases that impose a stricter standard on the party invoking the right.
So going by that logic, Attorney Camille, it seems that it's harder to invoke the right to speedy disposition of cases in administrative cases rather than invoking the right to speedy trial in a criminal case.
Yes, that is correct, Attorney Mike.
Why is that?
Because the party invoking the right to speedy trial in a criminal proceeding does not need to show that they actually suffered injury. This is because criminal proceedings have highly burdensome effects on the person being investigated. These people face possible detention and arrest. Unlike in administrative proceedings, the party who invokes the right to speedy disposition of cases has the burden to prove that they were prejudiced by the delay in the case.
So that means you have to raise it at the earliest possible time.
Yes.
And we don't have any information why An Waray didn't actually raise that issue while waiting.
No.
It was just know from the facts that they were saying nobody questioned our seat when we were serving it.
Yes.
All right.
They did not raise the issue of the right to speedy disposition of cases before the pendency of their case before the COMELEC.
Mm-hmm. Right. So, but when you come to think of it, if you look at the case, this happened in 2013. And so is An Waray correct in saying that this happened more than 10 years ago? Hasn't this case prescribed already? In fact, the nominee has already finished serving her term. So what's the issue?
Well, the court clarified that the 5-year prescription period under the Omnibus Election Code applies only to election offenses. So sections 261 and 262 of the Omnibus Election Code lists which acts are considered election offenses. The petition in this case is to cancel a party list registration, which is not among the acts considered as an election offense. So the court said that the 5-year prescription period does not apply in the present case.
So, Attorney Camille, what's our takeaway from this case, especially for party list groups, now that the filing of certificate of candidacy is fast approaching?
So party lists must always remember to follow the laws and regulations for elections, because there is a danger that if they do violate these laws and regulations, their registration can be canceled by the COMELEC.
And it can have repercussions on their nominees, even 10 years after.
Oh yes, definitely. Like in this case, it did affect their current nominee to the House of Representatives.
And yeah, we've seen news reports about another party list taking over the slot for that nominee. So, well, that's the case of An Waray Party-List versus COMELEC for you. Thank you, Attorney Camille, for joining us today.
Thanks, Attorney Mike. Thanks for having me, and see you guys again soon.
All right. And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for An Waray Party-List versus Commission on Elections, GR number 268546. Here's Stiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week. The Supreme Court ruled that buyers of defective brand new motor vehicles may choose to enforce their rights under any available law. The court held that Republic Act No. 10642, or the Philippine Lemon Law, which applies to brand new vehicles, is not an exclusive remedy. The Lemon Law allows the manufacturer, distributor, or dealer at least 4 separate repair attempts before replacing the defective vehicle. On the other hand, the Consumer Act, which applies to durable and non-durable consumer products in general, gives the supplier 30 days to correct the defective product. According to the court, there is nothing that prevents a consumer from availing of the remedies under the Consumer Act or any other law if the subject of the complaint is a brand new vehicle. Meanwhile, the Office of the Bar Confident, or OBC, issued a reminder to 2024 bar examinees with deferred documents to upload digital copies of these documents through the Barista online platform and submit physical copies to the OBC on or before October 15, 2024. Failure to comply will result in disqualification, and the examination answers of non-compliant examinees will not be checked. In another decision, the Supreme Court ruled that demotion, verbal abuse, and indifferent behavior by an employer that forces an employee to resign constitute constructive illegal dismissal. Constructive dismissal happens when an employer creates such unbearable working conditions that the employee feels forced to resign. The court stressed that actions demonstrating extreme dislike and hostile behavior, such as demotion, uttering insulting words, and apathetic behavior toward an employee, constitute constructive illegal dismissal when such actions cause the employment conditions to be so unbearable that there is no other choice but to resign. The court held that the standard for constructive dismissal is whether a reasonable person in the employee's position would have felt forced to give up their employment under the circumstances. While the court said that strong words may be exchanged in the workplace where there are bound to be disagreements, these should not degrade the dignity of employees to avoid a hostile work environment. The Supreme Court has extended registration to the 6th Asian Mediation Association, or AMA Conference. The AMA Conference will be held from October 15 to 16, 2024 in Manila. Interested lawyers, mediators, and alternative dispute resolution practitioners may still register for the conference until October 10, 2024 on the Supreme Court website. The conference, themed Harmony and Strategic Innovations in Mediation in ADR, will gather global experts in mediation in ADR, including luminaries, practitioners, members of the academe, and advocates from across Asia and beyond. The two-day conference will feature 8 sessions designed to foster dialogue, inspire discourse, and share insights on various aspects of mediation and ADR. For more information, please contact the conference secretariat at amaconference.secretariat@judiciary.gov.ph. Also extended are the registrations for the Zamboanga City leg of the regional consultations for the proposed amendments to the Rules of Civil Procedure and the proposed amendments to the Rules of Criminal Procedure. Interested participants may still register until October 1, 2024 for both the CivPro and CrimPro regional consultations by visiting their respective microsites on the Supreme Court website. And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, and YouTube. You can also catch previous editions on our website. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Irania as researcher, Don Ryan Balza and Jerome Batumalake as sound editors, and Tyke Flores as web editor.